webinar today, protecting yourself at work in a challenging new climate. First of all, I really want to extend a huge thank you on behalf of the RTSO to all of the respiratory therapists in Ontario and for everything that you're doing. This is a time that none of us ever anticipated we'd be working in. And so, you know, many of us have been around for a number of decades and we've been through SARS and H1N1, but this is way beyond what we could ever imagine. So we just want to say how grateful we are for everything that you're doing and appreciate all of the lives that you're saving. So thank you so much. I also want to thank our guests, but before we get there, I just want to say a couple of words on behalf of the RTSO. I'm Renata Ria, and I'm the president-elect. Paula, our president, sends her best wishes. Paula Smith, she couldn't be with us today. But for those of you who are members, again, thank you. For those of you who haven't taken the plunge yet, I urge you to seriously consider what the RTSO is doing to support respiratory therapists in Ontario. So please consider a membership. It's an investment in you. We're a volunteer organization and we need your support to continue being your voice in Ontario. The pandemic has changed the working environment significantly. On a positive note, the RTSO has a chair at the table with the Ministry of Health. We are a part of the Coalition of Regulated Health Professionals in Ontario. And we have a key advocacy partner with Stosic and Associates, and they are a government relations and public affairs group who help us to advocate for you at the Ministry of Health. Today we have Brian Whitwham and Rohit Kumar from the law firm Miller Thompson, and they're located in London, Ontario. And they're sharing their time and expertise with us today to help us to protect ourselves in this challenging new environment. You've seen the short bios of both Brian and Rohit on the website as you registered. But suffice it to say that I'd like to, first of all, say a huge thank you on behalf of the RTSO for your time and to speak to us today. Both of these gentlemen have diverse litigation practices with experience in medical malpractice, professional discipline, and liability cases. And this is your opportunity to bring your questions forward. So we have a good number of people on the line today. And what we'd like to do is that we'll ask you to place your questions in the chat box. And for those of you who are familiar, you'll see a little bubble in the bar that says show conversation. And if you click on that, you'll see there's a conversation that will come down on the right-hand side. And please type your question into the box. We have a couple of our colleagues who are also joining us who will be looking after that chat box and will bring your questions forward to both Brian and Rohit. So again, thank you so much on behalf of the RTSO, and thank you to all of the RTs out there for everything that you're doing. And I will turn it over to Brian and Rohit.
Well, thank you very much, Renata, and thank you to everyone for attending. Rohit and I are very happy to be with you today. Renata spoke to this a little bit already, but you know, it's obviously very timely that the RTSO has decided to hold this event. The COVID-19 pandemic has obviously had a huge impact on all of us in different ways, but for respiratory therapists in particular, for your group, you know, from our perspective, this has been really a sea change for many of you, even more so than when we're looking at other health professions. And so, as we'll discuss in this presentation, the pandemic has brought a lot of focus to respiratory therapy. It's certainly increased the demand for qualified respiratory therapists across the province, and that's on both sides in terms of new candidates coming through the you know, the colleges and post-secondary education systems, but also an increase in the number of professionals who are choosing to return after retirement and try to help with the very increased patient demand, particularly in hospital settings. But all of these circumstances have certainly increased the risk that respiratory therapists are operating under, and that's why the theme of our presentation for you today is really all about risk management in a regulated health setting. So we have provided some slides, and we'll go through that. Our goal here is not to sort of get bogged down into technical legal points, but to try to stay focused on the more practical considerations that are, I think, useful to keep in mind as you're interacting with patients, with their family members or with other health professionals in, what's a very new environment for everyone in a lot of ways. And I should mention, so I'm in the London office. My colleague Rohit is in the Waterloo office. So we're kind of, usually we would want to be able to do something like this with you in person. Obviously, in these circumstances, we can't. So we'll sort of try to go through this back and forth a little bit, and we'll be allowing a little bit of pause between the two of us so that we're not speaking over each other. But Renata, if you could go to the next slide. And first, and sorry, Rohit, did you have anything to add just before I go any further?
No, I think that you've set up the theme very well, Brian. We really do intend to focus on the means by which you can reduce your civil liability and regulatory risk as members of your profession. And part of that involves informing you of what the law is around the civil and regulatory risks that you face. That being said, I would like to echo Renata's comments. Both Brian and I certainly appreciate the role that you are all playing in keeping us alive and safe and healthy during this pandemic as frontline workers in your profession, and we all owe a huge debt to you for that.
Absolutely. And the slide that you're looking at on your screen right now is actually the disclaimer portion, we'll call it. And we joked with Renata in preparation for this that I suppose it wouldn't be a lawyer's presentation without some form of disclaimer. But there is a practical piece of advice to it. So we are going to seek to provide an overview, of the kinds of risks and the kinds of practical considerations you want to look at. That wouldn't be legal advice. One of our primary takeaways from this would be that it's very important to try to engage counsel whenever you run into a situation where you might become part of a legal proceeding, and that's because the actual legal advice can really get very, very specific to the set of facts that you're dealing with. So this is really provided more as an overview. Renata, could you go to the next slide, please? Thank you. So this slide concerns the COVID-19 impact that it really at the moment, from a legal standpoint, the impact of this pandemic is not yet known. There seems to be a lot of concern across the board with respect to the pandemic creating an enhanced level of risk and actually leading to more civil litigation than one would typically see, and leading to more regulatory complaints than one would typically see. We have heard anecdotally from the College of Respiratory Therapists, your regulator, that's consistent with what they've seen. They have seen an increase in regulatory complaints and an increase, therefore, in the number of investigations that are having to be done. That's anecdotal. We don't know exactly what that increase looks like yet. I should mention that a lot of these colleges, your college included, would be publishing annual reports, and the annual report from this college is not yet out, but it'll be interesting to see, what that increase looks like in a real numbers sense. But either way, when we're sitting back as lawyers and looking at the set of circumstances that the COVID-19 pandemic has created, it's easy to see how it does create an increased risk for everyone who's trying to work in a highly regulated health environment, because you've got greatly increased patient admissions at hospitals. You've got a very significant increase in demand for healthcare from patients, both in the community and in a hospital setting. And because of the nature of COVID-19, there has obviously been a greater number of adverse outcomes. And I should stop there. Those points right there tend to be enough to lead to an increased number of malpractice suits. Beyond that, more generally, and I think this point applies a little more to respiratory therapists, there's been greater attention directed certainly to healthcare providers and just greater attention in general directed to respiratory therapists because of the important role that people in your profession have to play as part of the care strategy that has to be activated for a lot of these patients. And in conjunction with that, we also see that the health colleges more generally and Plans Council through this pandemic appear to have become increasingly aggressive. In part, for Plans Council, it might be driven by them trying to follow up every adverse outcome. In part for colleges, there's been some procedural efficiencies, frankly, from the standpoint that they're operating virtually, and they're looking to make sure that they continue to act and carry out their mandate. And I should mention, this is not an issue that's unique to Ontario. It's not unique to Canada. It really is an issue that is affecting other countries right across the world right now. Certainly, we've seen scholarly commentary out of the United Kingdom, for example, or other areas of Europe, wondering whether health professionals should be immune from liability. We have seen certain legislatures wanting to take action in countries like Italy and elsewhere in Europe on potentially enhancing the legal protection that gets afforded to health professionals. And then we've seen sort of more informal signs. I think, Rohit, you mentioned that you had seen certain statements from some of the colleges in that context as well, if I recall.
Yeah, so I recently acted for a nurse in a college of nurses matter, an investigation that was the result of a mandatory report. And while I can't go into the details of that matter due to confidentiality reasons, I can advise that as part of the submissions that we made to the college in asking that it take no further action against the nurse that we represented, we referred to the college's public statements and statements to its members that it would be sure to assess standard of conduct issues in light of current circumstances, including the exigencies posed by the pandemic, the strain on the healthcare system, the demand on the nursing profession in particular. And so we did make submissions, and that matter did result in the college deciding not to take any further action against our client. But we did make submissions in that particular case about staffing issues at the institution, the hours that our client was working, those kinds of things to draw the college's attention to the unusual and difficult circumstances that their member was working in due to the pandemic. And so I think Brian and I want to be conscious not to give you a false sense of comfort that your actions at this time will be afforded greater latitude. And at the same time, we are telling you that the acts of healthcare professionals are being subjected to greater scrutiny, and I'm sure you see that all over the place. But I do think it's important to note that at least some colleges have expressly recognized that when looking at whether or not a member met the standard of care, met the standards of the profession required in the circumstances, they will look at certain contextual factors, including in particular the impact of the pandemic.
Right, that's a good point, and it goes along. The two sort of go hand in hand. There's an increased risk, of course, that this pandemic has created, but thankfully, at least a lot of the colleges, and I believe that your college has made some comments along similar lines. There's been some acknowledgement from regulatory colleges that they need to take into account the very unusual circumstances healthcare providers are having to deal with. The same would be true in a civil proceeding. And Renata, if you could go to the next slide, please. So when we're looking at the kinds of risks that health professionals are going to face on any given day, there's really two forms of risk primarily that you're looking at in a legal sense. And that would really be the risk of a civil action, so a lawsuit, and then the risk of a regulatory complaint. Now, Rohit and I both have experience dealing with both, and dealing with both from a health standpoint. But we'll start with the civil action, because I think that a lawsuit is what people are probably a little more aware of, or cognizant of when they're thinking about the kinds of risks that they're dealing with. And typically, if a health professional is going to be drawn into a lawsuit, the claim is generally going to be what's called, negligence at law. So the notion that there's been conduct that's been negligent, that's led to a bad outcome. And Rohit, you can probably speak a little more to that in terms of what the actual elements of a negligence claim tend to look like.
Yeah, so at law, it's very well settled that there are particular elements of a negligence claim that a plaintiff must establish in order to recover damages, which is really financial compensation for some form of injury that they've suffered as a result of the defendant medical practitioner's conduct. The first primary element is what is called the duty of care. And this arises on the basis of the relationship that exists between the medical practitioner and the patient. And in that medical practitioner patient context, a duty of care will almost always be established and recognized, because the patient doctor relationship is one of the categories of relationship that the law basically recognizes automatically, gives rise to a duty of care. And certainly in a traditional doctor patient treatment setting, like in a hospital or clinic. I mean, if it's something that's happening outside of that setting, there may be a question in theory about whether there's a duty of care that arises, but certainly in the traditional practice setting, whether in the community or in a hospital, there will be a duty of care that is recognized. Then the second primary element is the standard of care, and that goes to what is the what are the standards that a medical practitioner is required to adhere to in treating a patient. It will depend on what the clinical indicators are, what the treatment provided was, or what the advice was, and what the outcome then was. And as noted here, generally a court will require there to be expert opinion evidence on whether the standard of care was met or not in a particular set of circumstances. Now, I think it's helpful to note here that regulatory standards of your profession, which are set out in directions and guidelines and requirements from the college, will inform whether or not the standard of care was met or breached. But a court is going to make its own determination on a number of factors and issues that don't entirely necessarily correspond to the way a college would assess the same type of conduct. The court is going to make a finding on all of that as to whether the standards were breached. And so the plaintiff will, who has initiated the lawsuit, will likely have an expert report that the standard of care was breached, and the practitioner, the defendant, will have its expert opinion that the standard of care was not breached, and a judge will essentially decide which opinion it favors, and ultimately will decide whether the standard was met or not. The third major element is indicated here is causation. So a plaintiff has to prove not only that the standard of care was breached, but that it caused some form of injury that is compensable. And so that it doesn't have to be the sole cause, but it has to be a contributing and substantially contributing factor. Okay. Then the plaintiff has to prove damages, which is really in a medical malpractice context, it is generally some form of physical injury or impairment that then gives rise to the need for financial compensation. So, for instance, somebody's injured and cannot return to their work, It will depend, the quantum of their damages will depend on the type of work they did. And if they can do some work or no work, there will have to be assessments made of what the financial losses are that result from the physical injury that was caused by the breach of the standard of care. And so I think that, is probably about the level of detail you need on how a negligence claim is pursued. I would note that while negligence will be the most common and typical, what we call cause of action that a plaintiff will pursue against a medical practitioner, it is possible that a patient pursues another tort, which is a cause of action at law that gives right to claim for damages. And that could be battery if it is something like sexual abuse that is alleged. And if the issue is that a patient didn't consent to a particular form of treatment, then there could be claims in battery as well as negligence. But negligence will be the most common.
Yeah. I think that's a good point. And just to sort of step back for a moment, so I'm not sure how many people may have been named at some point in a lawsuit, but it certainly happens a lot in the medical field, in any health field, and it would begin with you being named as a defendant in a statement of claim or a notice of action. Sometimes people have a bit of a knee-jerk reaction to that, which is very natural. And there's sort of a thought process of, this lawyer must have done this investigation and then must have determined that I've done something wrong and that's why I'm being sued. Sometimes that may be the case, but to be honest, what we tend to see in any kind of negligence action brought against health professionals, especially in a hospital setting, it tends to be a policy of sort of sue first and ask questions later. So, plaintiff side counsel will go ahead and they will bring a claim and they will simply name everyone who happens to have been identified as playing a material role in the hospital chart. So that may include occupational therapists. It will most definitely include physicians, perhaps from multiple specialties. It will include the nurses. It may even include administrative officials where there's some concern that it may have been a hospital protocol or administrative issue that was creating the issue that led to the adverse outcome that they're dealing with. And that's just how things tend to work, is a lot of plaintiffs' counsel will use the litigation process itself to figure out where responsibility should lie. And they will go through the rules that we have around disclosure and the need to provide information and the need to question people under oath to try to figure out what the focus should be. And so all that's to say that if you're ever named in a lawsuit, you want to make sure that you engage counsel immediately. But to just keep it in perspective, at that stage, all it really means is that you've been named and you're a long, long way from a statement of claim being made or getting sued to any findings on the merits actually being established in court. At this point, the procedural track in terms of the amount of time it takes differs a bit by region, but certainly I think you would be looking at 2 years at the very least, on any kind of negligence claim brought in this kind of area, in terms of getting from the statement of claim all the way to trial. And frankly, the like everything else, the COVID-19 pandemic has had a big impact in actually elongating that procedural track, such that there's a lot of matters that don't even start getting set down for trial until 3 or 4 years have passed. It's not unusual to see those kinds of things. The one other practical piece of advice that I would that I think Rohit and I would probably want to stress with this is, if you ever are named in a lawsuit, I think you just want to make sure that you understand what counsel is being engaged to make sure that there's someone there to protect your interests. If a lot of you are working in a hospital setting, and this may even be true for those in a community setting, oftentimes the hospitals or the clinics may have you as part of that hospital's defense under an insurance policy, and that's fine, and that's very helpful to know. But I think you just want to be certain that you have counsel in place, and I think you want to give some consideration, and perhaps Rohit, you can speak a little of this, about ensuring that not only is counsel in place, but that your interests will be addressed through that lawyer.
Yeah, I think, everyone retains a lawyer in litigation to advocate for their interests. But sometimes, and both Brian and I have seen this, when you're engaged by an insurer at the early stages of a matter, you need to advocate to ensure you get your proper representation. And, I don't want to encourage you to be um, overly skeptical that say a hospital's insurer is going to take the proper steps to ensure you, as well as the other parties named as defendants in a civil action, like the doctors or nurses, are that the insurer is acting properly or in good faith to get a counsel appointed to represent all of you. But I think we can all appreciate that there are circumstances in which co-defendants may not completely be aligned in their defense of allegations by a patient or in relation to an outcome that is being litigated as a malpractice suit. So while you need to cooperate with the other defendants and the insurer that's going to appoint counsel for all of you to some extent, you also want to make sure in that early stage of the process that you're satisfied that you're going to have someone who is properly representing your interests and is not going to be prioritizing the interests of other defendants over you. Now, Brian and I have represented individuals that share the same lawyer as multiple co-defendants where there's no conflict. I mean, there can be a conflict of interest that arises because people start pointing the fingers at each other, and that's obviously going to be a problem. But there are many situations in which it may not be as obvious that there is an alignment or non-alignment of interest. And so, where everybody is aligned and there is no doubt about that, then they can be all represented by the same counsel and there's no problem. But you just got to be attuned to the possibility that either at the outset or at some point during the process, it may develop that your interest as one of multiple defendants starts to diverge from the interests of the others.
That's exactly right. And I think at the end of the day, it's just something you want to be aware of. And if you think there is an issue, you want to try to raise it with whoever the appointed counsel is at an early stage, because most lawyers who are in this area should also be very sensitive to that and would not want to proceed if there is a conflict within the group. So to put it, to try to think of an example that may be directly relevant to a situation that you could face, if there was some kind of adverse outcome that rested on an allegation that there was a breakdown in communication, right, between the health team, and then if you have a respiratory therapist and a nurse, both within the same group of defendants, but actually at the end of the day, they may have a real disagreement over what was communicated or how, and what should have been communicated and how. And if that is really material to the litigation and they are therefore sort of pointing the fingers at each other, that's a good example of a situation that should be raised with a lawyer at an early stage to say, I think that certain members of this group are actually going to have to be given separate counsel so that we can proceed, because we can't have a group under the same umbrella, so to speak, if in fact there are some breakdowns with respect to how things actually unfolded here. And by breakdowns, I mean breakdowns of view as to how things did unfold or should have unfolded. The other point, though, that Rohit makes is very important, is that not every disagreement is going to be some form of conflict. Plaintiffs' lawyers are very alive to this, especially in a hospital setting. And that's why they sometimes want to name a large group, because they are quite happy to try to create discord and create issues that they think might drive some form of conflict. Because if they can have a situation where ultimately it's going to trial and you have two different defendants pointing at each other. Let's take a respiratory therapist and a nurse as our example, and they're both testifying against each other in court. It makes the plaintiff's job very easy to just say, well, look, Your Honor, clearly we all agree that something terrible happened. It's just a matter of determining whether it's this person's fault or that person's fault. And that's another issue that your counsel is going to be kind of thinking about anytime you raise this sort of issue, to say, is there a real conflict here, or really is this something that we can park and just proceed and present the plaintiff's counsel with a united front? So I think that's all for probably the civil actions overview. Ron, if you could go to the next slide.
Yeah, I have a question here, and it's about regulated healthcare professionals versus unregulated. Is there any change? Like, would anything be different if the person did not or didn't belong to a regulated health professional group?
Within a civil lawsuit, in terms of how the lawsuit would unfold.
Mm-hmm.
So it would depend, and I'm going to let Rohit speak to this as well. My initial reaction to that would be that it's going to depend on what involvement that person had. So a health professional is going to be evaluated on the basis of what the standard of care would have required from that person in the circumstances. If we're talking about an administrative official, really that person would be looked at in the same way, but not, they're not going to be evaluated to the standard of a nurse. They'll be evaluated to the standard of an administrative official in the same situation. Now, where you would create a more significant problem, though, is if you had a non-health professional who was taking steps that were really within scope of a health professional practice. Right, that's where that could become a significant problem for a non-health professional.
Okay, thank you.
Rohit, would you add to anything to that?
No, I mean, I think all I would say is the lawsuit, the cause of action of negligence is available equally as against a regulated professional and non-regulated professional. So let's take a, Brian mentioned an administrative staff member, say, of an institution. Take a personal support worker or something who doesn't have the same regulatory standards and college oversight. They could still be sued. They could still be found to have owed a duty of care in the circumstances. It really, as Brian says, come down to what the standard of care applicable in the context is. And in the absence of regulatory standards, it may be a little more difficult to establish what the appropriate standard of care was in the circumstance. So specifically, what was expected of this non-registered professional in those circumstances.
So so I just want to clarify from the person who's asking the questions. He says that yes, it would be in relation to a civil suit, and some of the examples that he's posing are, as an example, a perfusionist, a physician assistant, or an echo technologist. So they are healthcare professionals, but not regulated. So they're registered, but not regulated.
Okay. And so when we're looking at the standard of care for those individuals, you would need to have evidence to establish what the standard of care should be for those individuals. And that is going to be done often by getting an expert to testify as to what that standard should have been for that individual. We get into lots of conflict in a legal setting on the nature of the expert who's to be used in that setting. So you wouldn't have an orthopedic surgeon trying to speak to what the standard should be for a perfusionist. In fact, we even get into disputes where you may have doctors of similar specialties, but one works in a very rural setting and the other works at Credit Valley. Well, they're not going to be in the same circumstances, and that may have implications for an opinion being provided on what's supposed to happen in that setting. So the whole point is that the standard of care analysis in a negligence action is supposed to be very specific to the person. It's never going to be used with one brush. And that sort of goes to the earlier point about suing first and asking questions later. I mean, it's, to some extent, it's a natural result of the fact that these things are very complicated, and plaintiffs' counsel are always going to be concerned about their 2-year limitation period, because they have 2 years to sue from the point that the nature of their claim was discoverable. So from the point that they really should have understood that they had a lawsuit, they have 2 years to try to bring it. Especially when you have a lot of health professionals involved, it can be very difficult to determine where there's been some kind of breakdown, and the litigation process allows them to try to conduct that investigation. And I'll give one brief example, but we had, I was once involved in a very complicated case where it was a woman who was admitted to a hospital with all kinds of very strange symptoms, and she was evaluated by a large number of people. No one could figure out what was wrong with her, and then she ended up being put onto the psych ward for like a 6 or 8 week period before I believe it was an occupational therapist realized that she had a visual deficit on the right side, and lo and behold, they ended up finding out that she had some form of brain infection, so a physical issue that should have been spotted at a much earlier stage. The plaintiffs' counsel followed this usual approach, trying to name absolutely everyone, but strangely enough, they did not name the hospitalist, who was the person primarily involved with quarterbacking that individual's care. And that litigation, from a defense standpoint, ended up going much further than one might expect, because they didn't really have a great case against the other health professionals that they had named, and they had also sunk themselves on the limitation period against the one health professional who they probably had a decent claim against. And so that's just an indication of why, Rohit and I are both defense minded. We both admittedly probably have a defense bias on these issues, but to be fair to plaintiffs' counsel, that's one of the reasons that you do see that approach often taken in a lawsuit of just naming everyone who's in the chart.
Okay, thank you. I have one more question here. It says independent of the lawsuit in terms of involvement, and the person has in brackets, as an example, you're off duty. But as a registered respiratory therapist, you're asked to speak to the standard of care analysis. Is there any repercussion to this expert?
A repercussion to acting as an expert?
It says, is there any repercussion to this expert speaker?
To the expert speaker themselves. So if when you're an expert, actually, Rohit, do you want to take that first, or?
Yeah, I think that if you are asked to provide an opinion in a legal proceeding, there are probably a number of factors that you want to consider. But if you ultimately decide that you are qualified, experienced sufficiently to provide an opinion, and you want to serve as an expert, then you shouldn't feel like there are negative repercussions for testifying in that manner. In a civil proceeding, certainly there is no reputational, say, consequence that flows from the court's assessment of your opinion, other than to the extent that the court disagrees with your opinion, finds that prefers the other expert's opinion. And so, you can put yourself into a situation where you are exposing yourself to criticism. But, if everybody was unwilling to provide an opinion because of fear of professional reputational consequences, we wouldn't be able to get to the truth of anything. And I might be being a little idealistic when I say this, but I think individuals who have the expertise and the qualifications to assess conduct and provide an opinion on whether that conduct met a standard of care should feel free to do so. You just want to ensure you take the proper care in developing and forming your opinion and in expressing your opinion, that you are not going to be perceived as having done so shoddily or without due diligence and attention and care. And part of that is ensuring that the lawyer who is representing the individual for whom you're providing the opinion is you feel comfortable working with them to get the information you need. And this is, I think, the most significant factor in providing an opinion. The opinion has to be independent, right? And so, often the reality is that experts are hired by either side. They're paid for their services and their time and their reports. And one side gets a report that's favorable to them, the other side gets a report that's favorable to them. And experts are often referred to as hired guns in litigation, right? But if you are being asked to provide an opinion and you are providing an opinion, you need to ensure that it is independent and it is an independent product of your judgment and expertise, and that nobody is influencing your conclusions, that you've got proper access to all of the facts, you've considered all of the facts, and you've rendered an independent opinion, and you will be required to attest to that to the court. You will need to confirm for the court that you are providing an independent opinion. And so, there are a number of things to be concerned about if you're wading into that kind of work. But I don't think that you need to be worried. If you do a good job, there's not going to be any negative repercussions. Right? I don't know, Brian, if you maybe have a less idealistic view of that than I do, but that's sort of what I perceive to be the main considerations there.
I think that's right, actually, and I think that the same is true whether or not you're testifying in a civil proceeding, or you may end up testifying in a regulatory proceeding at some point for the same reason, to opine for the college or perhaps for another respiratory therapist on the steps that person took. In either case, you would have to you'd have to sign a form saying, I've been retained by the prosecution or the defense or the plaintiff or the defense. And but I'm providing my own objective and honest opinion based on the information that's been given to me. And that's in essence the nature of your obligation as an expert. You're there to try to assist the court or tribunal in figuring out what should have been done in these circumstances. That makes sense.
Thank you. There's two more questions. It's great. Lots of engagement. This question is with regards to timelines, and it's in regards to caring for children. The question is, can you speak to any differences in timelines when caring for children? And I anticipate that it's, you spoke about sort of 2 years, 4 years. When you're dealing with pediatric cases, do you see that the time is longer, shorter? Can you speak to that?
Actually, it's a very good question with a very, very material difference. The timelines that are in place actually apply to people who are over the age of 18. They don't apply in the same way to minors. So you actually see this a lot. You see it. You don't see this as much actually in the health sector, but in motor vehicle accident litigation, you see it where if someone is in a terrible crash at 14 years old, then the plaintiffs may in fact wait all the way until that person is 20, because they will get 2 years from the time that they turn 18 in order to bring a lawsuit. And that will be done on purpose by plaintiffs' counsel, because they're following that person along to get a sense of what the damages look like. And they think that if they've got the time to wait until 20, and it looks like this person's going to continue to be very seriously affected by this, they want to allow some time for that to sort of crystallize and demonstrate that, here this person is 20 years old, this happened 6 years ago, and this individual is clearly going to be affected for a very long time. Now, that's less common, I would suggest, in a medical malpractice or health malpractice type of lawsuit. And the reason is that as time goes on, and as memories fade, the evidence it tends to be not as clear for both sides, and that often isn't very helpful to plaintiffs' counsel. But certainly, from a legal standpoint, it's a very material consideration on the limitation period for minors compared to people who are of age. Rohit, did you want to add anything on that?
No, I think that encapsulates the difference.
Mhm.
Okay, thank you. There's another question here, and actually this one, I saw an earlier one that had been posted that's along the same lines and very relevant right now. It's saying, as acuity increases, oxygen devices are in short supply. Ventilator supply diminishes with triage decisions led by a physician. If a ventilator or a high flow oxygen therapy device is denied to a patient, can a family bring a suit claiming that this is unethical? And this person is saying, you know, I'm an RT that's administering these therapies. And we saw a similar question posted earlier in the week as well, in the same regard.
It's a very good question. I mean, when people say, can someone sue for that? I mean, people can and will sue for basically anything. It's funny. Oftentimes people will ask, how do I avoid a lawsuit? And that's, you know, oftentimes that can't necessarily be done, though it is, once again, a different question from bringing a lawsuit versus actually establishing liability on it. I think that consideration is going to come down to what kinds of resources did the hospital have in place for this person? Was he or she asking for, just to pick extreme examples on the two sides, was he or she asking for a device that, you know, where there were, you know, 6 machines not being used just down the hall, or asking for a device that is at this point only being used or deployed in England? Right. And so those kinds of considerations end up coming into play with respect to the standard of practice in the circumstances. There's an additional point that it raises, which is that the acute nature of these things and the faster pace that hospitals are having to operate under is precisely what people need to be a little bit concerned about when they're going through their own actions. And it comes down to you sort of trying to do the best you can within with the resources that are made available to you. And at the same time, if you feel that you're not being given the equipment to do your job, or if you feel that you're being given patient loads that are just entirely unreasonable and cannot be managed, you know, in a way that satisfies the health of these individuals, I think you certainly should feel, you know, confident in saying so and in raising that concern. And because oftentimes with respect to lawsuits, we do it. I would suggest over time, it's hard to actually say you see more of them in smaller hospitals than larger hospitals, but you often see some similarities in the nature of the lawsuit brought in certain smaller hospitals, and it has nothing to do with the actual people involved or their expertise. At times, it can stem simply from the resource issues that certain families might be objecting to. Rohit, would you have anything to add on that?
I think whether the standard of care was met in a particular set of circumstances will depend always on the totality of those circumstances. And so, you know, assessment of a triaging type decision will be based on all of the facts that went into that triage type decision. And if that, as Brian said, you know, the evidence establishes that there was a reasonable basis to prioritize one patient's care over another and deny equipment or treatment to one patient to prioritize the care of another. I mean, in the unique circumstances of this pandemic, that might be entirely appropriate. Or depending on the particular facts, it may not be appropriate. And so it is really going to depend on what the evidence is about what went into the decision, why the decision was made, was it defensible? You can't sort of draw a bright, clear, universal line in the sand and say, in every situation, that type of decision is going to be either ethical or unethical.
That's really helpful information, because I think essentially what you're telling us, after all is said and done, you know, I was listening to a radio broadcast about a week and a half ago, and they were talking about, you know, a form that has been put in place in the event that there needs to be a triage situation. And so what I'm understanding from your explanation is that as respiratory therapists, while we would not be the ones making a decision on who receives a device, a ventilator as an example, or a high flow oxygen setup, but what is important, I think, for us as health professionals is to ensure that within our own institutions that there are directives and the directives are in place so that resources can be reviewed, and we have the appropriate medical professionals who are doing that. As an example, my understanding is with the ventilator situation that 2 intensivists would need to independently review the situation and come back to the table. So what we would want to ensure then in our institution is that we have those qualified individuals to be able to do an appropriate assessment. Is that sort of what you're saying to us?
I certainly think that's part of it. And I think it's also ensuring that with respect to your specific patient load, making sure that there's very clear communication with those intensivists who are making those kinds of decisions, so that there's no notion of, a particular patient's concern somehow falling through the cracks, right? Typically what will often happen and lead to a lawsuit is some form of communication breakdown. And so it's about making sure that you've got those people in place, and then making sure that they have the information to go ahead and make the assessment. Their decision may still be attacked at the end of the day, but I think you want to try to make sure that at least from your standpoint, in terms of how you're documenting everything and how you're communicating with everyone, there's no lapse in that line of communication on your end.
Yeah, I think just following up on that, I mean, if you're not the decision maker, obviously, but to the extent that you are being called upon or feel that you should be providing input into the decision, you should provide it, and you should document it to, in some way, so that there is a record that you provided the input that you thought should be a factor in the consideration of what to do in the circumstances by those who are authorized to make the decision.
Thank you. Further to that, this is obviously a hot topic, and again, really great questions. And I know that we could probably have you here till bedtime. But on the same vein, with RTs that are they're currently voicing a lot of concern, and I'm hearing it across the province about workload. The problem is, and this person is saying that the problem is that hospitals are being told to continue taking more and more patients in level 3 critical care. And so the respiratory therapists are really struggling with liability associated with these huge assignments. And, the person is saying it opens your eyes wide, because they're saying that we have the potential of 1 respiratory therapist to 20 ventilator assignments. And so, these are real situations. What's the advice that you would have for folks in those kinds of situations?
I think it's to continue trying to advocate for yourself and raise the issue where you're being put into that situation, right? At the end of the day, your own actions are going to be judged based on the situation you were put into, and you can only deal with the resources that you're given, right? So, but at the same time, I think that in a legal setting, there probably would be an expectation that you raise the issue, because what you don't want to have is a situation where you're saying, well, that's all that I was given and I was directed to do it. And then the retort might be from a co-defendant, if it's a hospital administrator, for example, saying, well, we didn't know there was an issue because the respiratory therapist involved or even the intensivist involved never raised it. Well, I think that's why it becomes important to actually follow these things through. And if you're being asked to monitor, 20 ventilators, it strikes me as a great example of a situation where you should say, look, this is not sustainable. I think we need to figure out what we're going to do with the system. And at least raising that issue, I think, is very helpful in being able to show that you were doing, the best you could at a later stage with the cards that you were given. Rohit, would you add?
I think the key is escalate your concerns, document your concerns, right? And it may feel like you're banging your head against the wall. It may feel like you're screaming into an abyss, but just continue to do it, because when the post-fact analysis comes as part of a litigation or as part of a civil or regulatory proceeding, if you're able to say, here it is, look, I spoke to this person, I spoke to that person, I complained about this, I questioned this, I expressed concerns about this, and it's all documented, you will be in a much better position than if you're saying, you know, I shouldn't have been in charge of 20 ventilator assignments, but I didn't raise it with anyone.
Right. And also, I guess the other thing that occurs to me, just as Rohit speaks on that, is that, you know, we're sort of raising the example of you and a co-defendant pointing back and forth, but a plaintiff's counsel is not trying to just look for one guilty party. What they want to do is try to show that there's some liability exposure on everyone, because they're trying to drive a settlement. And if they can get, you know, multiple parties or multiple insurers to be contributing to a settlement, that's what they want to do. So I think that where there is a real resource issue, you'll often see plaintiffs' counsel trying to focus their questioning on individual health professionals on, okay, there's a resource issue, that's a problem with the hospital, but what did you do to try to address that, if anything? And so it certainly helps, I think, if you're in a position to say, I did the following.
And the person who asked the question, he's also saying that a great way to raise this is at a corporate command center discussion, because these are put to minutes and are archived. So I believe it's going to be different in different settings. This Mike is coming from a tertiary center in southwestern Ontario, and so actually southern Ontario, not west, but anyhow. But I think that's a good point. There's someone else who's saying, how should we document concerns?
Well, they can be done in a couple of ways. I mean, if it's something that comes up in the course of your interaction with the other members of the circle of care for that patient, and it comes up in the actual, you know, directly related to a patient, it probably should be included in the chart. If it's a larger organizational issue, you know, sending an email to management to just sort of document your concern or the concern of your colleagues is probably another helpful way to do it. I think that, you know, Mike's example with the corporate command center is another possibility, just to make sure that there is something out there to say that, look, I have raised this issue and I've been trying to raise it, because we have seen, you know, I've certainly seen situations in the past where lawsuits stemmed from a resource issue, and, you know, I've seen it a little bit more in the physician and nurse context, but in both situations, I've seen it where the, you know, physicians especially are saying, look, we were being given a completely unreasonable caseload to deal with, and this is the best that we could do in the circumstances. It unfortunately does create that uncertainty, because that creates lots of room for people to argue. But the more steps that you actually take to say, look, I raised this issue, the better position you potentially put your own lawyer in to argue on your behalf that you were trying to do the best you could with what you had, and you did try to raise concerns about getting a better system in place, better resources in place, more timely decision making in place for the patient that you're dealing with.
Great, thank you. There's just another quick question about how long after retiring do you recommend carrying liability insurance? So obviously we have a couple of tenured therapists on the line who are wondering about liability insurance.
As a general, my thought process on that, I guess as a general approach, I would probably be thinking along the lines of a 3-year mark, recognizing that in general there's going to be a 2-year limitation period. There's probably some exceptions to that. If I was concerned about something that happened, you know, sometimes you can tell just based on a family's reaction or based on the nature of an adverse outcome that you're going to be dealing quite likely with a civil proceeding at some point from it. And if if it happened to be a minor, you may want to sort of think about it a little bit in your own circumstances and think about the likelihood that you're going to face a lawsuit, and therefore keep your insurance in place for a longer period if you think that person is, you know, below 18 and it's going to take a while. But mostly, you know, for the most part, I would probably be thinking along the 3-year mark after I retire, to try to let, in most cases, a cause of action should have been discovered prior to that, given the nature of your practice.
Okay. I know we're at time, but I wondered if you just have a couple more minutes. I just want to make sure that everybody feels comfortable on the line, because there's a question that it's absolutely related to what we've been talking about. And the person says that they feel like they may be putting themselves at risk for management targeting staff with disciplinary action if complaints are made. And I think that's absolutely not what you're suggesting. And I would be hopeful that that's not where management goes. However, I know there have been situations where this has happened. And so do you have a recommendation? Like if a number of people are working on a shift, as an example, that it's not just one individual who's feeling this. Does it help for the team to actually, voice their concerns and the reasons for the concerns? Like, do you have any thoughts there? Because the last thing we want are to have people who are scared to come forward, because they're by not coming forward, you're actually putting yourself at risk.
I think that's an excellent point. And actually, Ronaldo, just while we're addressing this question, would you mind just what we'll do is maybe we'll just go right to the very bottom slide just to put it on the screen, just while we're addressing this question, because that's the sort of we sort of include the final slide as the main sort of just some of the actual takeaways, and we'll just put it there for the moment. The concern being raised is a very, very normal concern to raise, and it's a constant tension, especially in a hospital environment, about how do I go about raising these concerns. In a legal sense, we would say you've got your obligation as a professional, and that tends to carry an obligation to advocate for patients where you see there being a real issue. In terms of trying to manage that, it can be difficult. I mean, we can all say that hospitals should not, hospital administration should not hold that against a professional, and that should not be done. But, it is an easier thing to say than to do. I think what it often comes down to is figuring out the manner in which to raise the concern. I think that working through a group is one very good way to do it, because you're saying, look, as a group, we've come together. We're concerned here about the impact on patients, and we're trying to do our best here, but we're very worried about adverse outcomes because we're just not able to keep up with demand due to certain systemic issues that are being presented right now. And if the focus of the inquiry, by the way, is on really that patient health issue, I think it makes it much more difficult for hospital administrators to take an adversarial approach in response, if that makes sense.
Yeah, that's very helpful. Thank you so much.
Rohit, would you add anything on that?
So I agree completely. I think what we're talking about is not necessarily making complaints about the acts of administrators or leadership team individuals or certain practitioners within a health team. What we're talking about is raising concerns and documenting concerns about patient care. And so, as Brian says, where that's the focus, I think it will be very difficult for any form of reprisal or disciplinary action to be taken. The reality is, when working in an organization and pointing out systemic deficiencies in how that organization is conducting its operations, certain individuals, namely management, will always get their backs up and will always, it's like the troublesome employee who's complaining about how the business is being run, is going to get some focus put on them. But I think, the greater risk to you in balancing potentially competing risks is that there is an adverse outcome to a patient that is somehow attributed to you. And so you need to ensure that where you genuinely believe that the best interests of patients are not being met, you're being put into an untenable situation where you can't possibly care for the number of individuals you're responsible for. The bottom line is, it is incumbent on you and necessary for you to protect yourself to raise those concerns.
Mm-hmm.
That's great advice. Thank you so much. I know we're at almost 10 minutes over. If I can ask you to maybe summarize in this with this last slide, Brian and Rohit, that would be terrific. And again, huge thank you from the RTSO and on behalf of our members, because I think for me anyways, I'm pretty sure that I'm hearing, I will hear the same feedback, that this has been incredibly helpful.
Well, thank you very much. We with respect to the last slide, this is sort of some of the takeaway points that we thought overall are particularly critical. And this is whether you're dealing with a lawsuit or whether you're dealing with a regulatory proceeding with your own college, right? And it's going to come down to the ability in a lot of ways to reconstruct whatever happened that led to the complaint or the lawsuit. And that's why the primary issue, and we've seen even notices from your own college. I know that Renata, you and I recently discussed one. It's very important to chart everything, chart your full interaction with that patient. I think that if people follow I assume a lot of you may follow sort of a SOAP format. If you do that, it's a good approach to sort of lay things out. You just want to make sure that you're always charting everything so that you can go back and try to recreate, because as time goes on, memories fade. Litigation takes a long time, and even regulatory proceedings are usually going to move a little more quickly, but you can still find that you're trying to when you deal with a lot of patients on any given day, trying to reconstruct what happened with someone even a few months ago can be a very difficult exercise. That's why it's so important to chart. And someone in keeping with that vein, by carefully charting things like informed consent, it tends to make you as a practitioner that much more careful about ensuring that you obtain informed consent. So those two go hand in hand, and informed consent is just another issue where we see a lot of lawsuits. Not to say that informed consent wasn't obtained, it's just that is an obvious spot that many patients or plaintiffs' lawyers will go to try to advance a claim. We spoke a little bit about communication breakdowns, but clear and seamless communication with the whole circle of healthcare providers is always going to be very important. One other point that, and I guess this point goes both to once again, the hospital setting, but also if you're in a community-based practice, right? Where if you were dealing with a patient on a visit one-on-one, it's going to be very important for you to document what happened when reporting back to, that person's family physician or whoever happens to be quarterbacking that aspect of the patient's care. And making sure you've got appropriate insurance coverage in place. And that would be twofold. Making sure that you have insurance coverage in place that's engaged where there's a lawsuit, but also some insurance policies, we do see them out there from time to time where they'll actually provide a separate set of coverage that applies for defense costs in a college proceeding. That can be very useful for health professionals to have. So if it is something that's being offered, it's probably worth investigating. And then the last one, which I think Rohit and I would both stress quite a bit, is timely engagement of legal counsel. It's often very important to get legal counsel involved early in the process. We have seen situations where someone doesn't come forward in a regulatory proceeding until they've already gone ahead and written very lengthy submissions to their own college about why they were entirely correct in the situation. And then they're sort of bound by, statements that have been made or actions taken when they may have done themselves more harm than good. Rohit, would you add anything else on this sort of general takeaway points?
I think, we focused on civil proceedings. We have some additional slides on regulatory proceedings, which I believe you'll be able to review at your leisure because they'll be made available to you. Brian did underscore the importance of documenting, charting your patient interactions. I would say that in the regulatory context, that can even take on added significance because you don't know what interactions with a patient or even a patient's family could give rise to a regulatory complaint. Unlike in a civil proceeding, you don't need to have any type of monetary loss or injury in order for someone to pursue a regulatory complaint. They can basically just be a person who is aggrieved by something that arose out of their interaction with you, whether even, you know, related to the treatment specifically that you provided or more generally their interactions with you. And so, you know, when you are responding to a complaint of that nature, your ability to go back and look at your chart, your notes and records, and say this is what occurred, this is what I told them. That's gonna be important, you know. So I would say that's a point to keep in mind in the regulatory context. And then lastly, like Brian said, you know, when a complaint is made against you in the regulatory context, sometimes I know that our clients are reticent to engage legal counsel. They think they can deal with it by themselves. They don't look at their insurance policy to even see whether they're covered. And, you know, you can misstep and respond to a complaint that you believe is innocuous or should be dismissed by the ICRC, which is the committee of your college under the Health Professions Procedural Code that will review these complaints. You know, you might say something that comes back to bite you. And so, you know, we're obviously in the business of representing people, and so we make the pitch to engage counsel for that reason, but also genuinely because we have seen in the past health professionals and professionals in general respond to complaints in a manner that ties their hands at a disciplinary hearing if in the unfortunate case their investigation or their complaint is ultimately referred to discipline. So again, important to retain counsel early in the process, and in particular counsel that has experience with these types of matters. And hopefully you've got a policy that will provide for defense costs, and you should be familiar with what your policy provides for.
Absolutely.
This has been really great information, and thank you so much. I know we've gone over, but again, on behalf of the RTSO, we really appreciate the opportunity to have you join us and share your expertise. This session is recorded, and as Rohit mentioned, there are some slides that have accompanied the talk, and so we'll make sure that the recording and the slides are available. And again, thank you so much. Thanks to everybody who participated. There were some great questions. And again, have a great weekend. Everybody stay safe, and thank you so much for everything that you're doing to keep the residents in Ontario safe and healthy. Thank you so much.
Thank you, everyone.
Okay,
Thank you very
bye.
much, everyone.